After oral argument in our first case, we will take a 15-minute recess. We ask counsel to join us on the third floor rotunda for coffee. Our first case scheduled for oral argument this morning is the Mosaic Company and CCMSI versus Larry Glenn. You may approach counsel. Counsel allocated 20 minutes per side for this oral argument. We understand there's a cross appeal in the case as well. Would you like to reserve some time for rebuttal?
5 minutes, please.
So noted.
May it please the court. Good morning. My name is Vanessa Johnson. I represent the appellant, Mosaic Company, and CCMSI. We are here because the JCC erred as a matter of law in regard to the award that he made on TT and TPD benefits without support of competent substantial evidence. This court has held that when the issue turns on a resolution of facts, the standard of review is competent substantial evidence. And to the extent that it involves an interpretation of law, the review is de novo. It is well established that a judge of compensation claims may not reject unrefuted medical testimony without providing a reasonable explanation for doing so. In this case, the JCC rejected unrefuted testimony from not only one doctor, not two, but actually 5 doctors. There was 4 opinions from doctors that were entered into evidence by way of testimony and 1 by medical report.
Are you referring to whether or not the claimant reached MMI?
Yes, ma'am.
Okay. Well, so what was Dr. Inga's position on that?
Yes. So Dr. Inga, so as you probably know, he was not the EMA for the instant litigation. He was the EMA appointed in prior litigation, which as of today, it was about 3 years ago, more than that. So when he first testified relating to prior litigation, he said that the claimant was not at MMI. However, in that same deposition, he said that the claimant would probably be at MMI if he had an updated MRI done to show that the pathology at L3-4 is either resolved or smaller. And so he established that then. Then when he was deposed a second time by claimant's counsel, which was in April of 2020, he did testify that, number one, he reviewed the MRI report of the updated study, which was done on October 4, 2019, and he did find that the pathology at L3-4 was resolved, or small. Well, I'm sorry, he said smaller, not necessarily resolved. So he said, yes, he's at MMI as of October 4, 2019. So there are instances where judges of compensation claims, where this court will reject their opinion if it's not substantial, such as if it's let me start again. There are times, obviously, where this court will uphold the judge's testimony, even if it rejects the unrefuted testimony of an expert. And this is where it's found that there's flawed medical testimony, or it's inherently illogical, or it's just not incredible. But that's not the case here. This court in Young versus American Airlines, it's a 2013 case. This court found that the JCC erred in rejecting unrefuted medical opinions simply because the judge was not persuaded. In Feature versus Total Employee Leasing, a 2011 case, this court held that a JCC erred for rejecting the unrefuted medical opinions because the basis for rejection discounted the context of the testimony provided by the doctor, and that's what we believe is what happened here. The JCC stated in his order that 3 of the 5 doctors, the 3 he's referring to is Dr. Kulkarni, Dr. Patterson, those are the 2 authorized pain management physicians, and Dr. Maniscalco, the employer carrier's IME, out of the 5, concluded that the injuries suffered in the workplace accidents were not the major contributing cause of the claimant's reported medical conditions. However, there isn't any testimony or evidence that supports that. In support of that statement, he cites to docket number 54, which is at the record at page 1370 for support. And this contains a snippet of testimony offered by Dr. Maniscalco, the employer carrier's IME, who's a neurosurgeon. And on cross-examination, he responded to a question and said, yeah, I do not believe that right now there's a relation to an injury to the accident. And that's what the judge cited in his order and said that that's why he rejects that opinion, one of the reasons why. But taking that in a vacuum and just taking that in and of itself, he just disregarded all of the testimony that Dr. Maniscalco offered. Dr. Maniscalco's testimony in his deposition was very thorough. He talked about the physical exam, the neurological exam that he performed, and he talked about how he reached the conclusions he reached. And ultimately, and by the way, all of the doctors that testified, they said that the claimant had degenerative findings. And the only compensable condition, or finding I should say, is the protrusion at L3-4, that's in the lumbar spine, as well as symptomatic thoracic spondylosis. Spondylosis is a degenerative condition. So that statement disregards Dr. Maniscalco's testimony because Dr. Maniscalco in his deposition, he was specifically told the employer carrier accepted compensability of the far lateral protrusion on the left at L3-4 and thoracic spondylosis, symptomatic thoracic spondylosis. Considering that, is there any objective relevant medical findings on clinical exam, on physical exam, neurologic exam, that would correlate with an ongoing disability or need for treatment? And he said no, and that's at the record page 1347 and 48. So then the JCC discounted the opinion of Dr. Patterson, and he cites to docket number 495, page 7, which is the record 1221. And what is found at that record is it's a one-page document of the first page of the DWC 25. There is no evidence in that document that Dr. Patterson, who by the way, he's the only one that didn't testify, there's no evidence in that document that the doctor said that his injuries suffered in the workplace accident were not the major contributing cause of his reported medical condition. But yet that's what the JCC supported his opinion for rejecting that testimony. And then lastly, in regard to the rejection of Dr. Kulkarni, he cited docket number 542 at page 9, which correlates to record page 1423. And here again, he cherry-picked a statement that Dr. Kulkarni said that he testified the diagnosis he had after the assessment was not causally related to the industrial accident. But this is, again, it's just in a vacuum, looking at that solely and not looking at the entirety of Dr. Kulkarni's testimony. Dr. Kulkarni did find that the claimant had degenerative findings. Like I said before, all of the doctors said that. He included that as an assessment because at the end of the day, he said he doesn't have any objective findings to warrant any injections or any need for treatment, other than Dr. Kulkarni did say, hey, he could require some over-the-counter medications, but he doesn't need any pain management. He could require some exercises at home, but this is for his subjective complaint of pain, not his objective complaint of pain. So the JCC's focus on these limited statements that he cherry-picked, it doesn't support the record because you have to take in totality what these doctors said, what all of the medical providers said, and each one of them did place the claimant at MMI. That's the sole issue here.
What about Dr. Kobe? I don't know if I'm pronouncing his name correctly, her name correctly. Was that determination of MMI limited to the field of neurosurgery, or did it also expand to the pain management?
The former, yes. He is a neurosurgeon, and he testified from the beginning, from the first time that he saw the claimant in June of 2018, or July of 2018. He testified, his his report says that the claimant was at MMI. He made referral to pain management at that time, and the specific referral was for evaluation and treatment for injections. And that's what sparked the litigation that ultimately led to the appointment of the EMA. So Dr. Kobe, who's the claimant's IME, even though, and I'm not sure if you've noticed this, but one of the reasons that the JCC, his rationale, is that he rejects Dr. Kobe's placement at MMI because when Dr. Kobe testified in March of 2021, he said, yes, he remains at MMI. Well, it's not in the record, but there were 2 depositions before, but it is in the record, and I can show you where in the record it is established that he did place him at MMI on July 20th, 2018, or July 19th. There's 2 dates, they get mixed up, but I think it's either the 20th or the 19th. And that's at the record, page 445. It's at 1221 and 1229 and 752. Excuse me. So he placed him at MMI even before, meaning Dr. Kobe. He placed, the claimant at MMI even before Dr. Inga saw him. And then he maintained MMI 2 times after that because he did updated IMEs.
Counsel, in
Yes.
reference to Doctors Maniscalco, I probably mispronounced his name as well,
Maniscalco.
Patterson and Kulkarni, the MMI assignment dates of those doctors predate the October 4th, 2019 lumbar MRI, which Dr. Inger, the EMA, provided was necessary to help determine MMI.
You're correct. You're correct. So just to clarify, Dr. Maniscalco, he was the he's a neurosurgeon. He was the employer carrier's IME. And when he first saw the claimant, I think it was in June of 2018, he said he wasn't at MMI. He said he was at MMI because he found that his condition wasn't related. And that's what caused that litigation going over to the EMA. However, when it was after the EMA, Dr. Inga rendered his report, took his deposition, the employer carrier accepted those findings from Dr. Inga and accepted that. And then the parties resolved the issues by entering into a joint stipulation. And, but I want to address your question. And yes, those dates of MMI were before October 4th, 2019. However, if you know, in the compensation order, the judge rejected Dr. Inga's placement at MMI on October 4th, 2019. He said that he flip-flopped or wavered. I'm not sure what the language was. So the record evidence, it supports that from a standpoint neurosurgically, from Dr. Maniscalco, there's just no evidence to warrant objective relevant medical findings to warrant any ongoing need for treatment. And work restrictions. And this court has held that a JCC errs in rejecting unrefuted medical testimony, such as in Calero versus Mount Sinai Hospital, the JCC erred in rejecting unrefuted medical testimony due to a single inaccuracy in history given by the psychiatrist. In General Electric Corp versus Cruz, that's a 1987 case from this court. The doctor whose testimony was accepted testified that the claimant reached MMI, but then the JCC disregarded that and rejected it and said, well, the claimant testifies he's still recovering. Well, this court reversed that and said that there was no evidence in the record to support the deputy's finding that the claimant had not reached MMI. So these cases are on point with our case. In our case, what the judge said ultimately, he says he rejects the testimony because, number one, he says that these doctors, the 3, is Dr. Maniscalco, Dr. Kulkarni, and Dr. Patterson. Patterson and Kulkarni are the authorized treating physicians. Maniscalco is the employer carrier's IME. He specifically rejects them, and he says it's because I don't believe that they would have given him restrictions. But that has nothing to do with being placed at MMI. When somebody is placed at MMI, there isn't a need to give restrictions. Sometimes they do. Sometimes they just check off that box and it says no functional limitations. Or sometimes they'll say, no, I think that they should adhere to these permanent restrictions. And at that time, they can proceed with the PTD claim. So he puts that in there, and then he also says that none of these doctors believed that he had an industrial injury. But that's not the case. That's not in, and I can list in the record where Dr. Maniscalco and Dr. Kulkarni, because those are the two that testified, they are aware of what is compensable. They just simply don't find that there's any objective relevant medical findings, and specifically because the updated MRI done on October 4th, 2019 compared to the one that was done in 2018, it showed that L3-4 finding as smaller or resolved. And they didn't find anything that correlated to the claimant's subjective complaints of pain. Okay, so I am going to go ahead and reserve the rest of my time.
I actually wanted to ask one question
Sure.
on the second issue, the self-help care.
Yes.
So when did Dr. Melvin first see claimant?
Dr. Melvin first saw the claimant on November 14th, 2019. And then the petition that was filed requesting reimbursement of what had already been paid was filed on February 9th, 2021, over a year after that initial visit.
Right, but what evidence in the record suggests that the claimant notified the employer before seeking self-help?
There's none, and the claimant even testified that he didn't. There's just no record evidence to support that.
Right, but isn't that a prerequisite?
Oh, yes, it is. Yes, I'm sorry if I misunderstood you. It is a prerequisite per Rodi. That's the first thing they have to do. That's the first requirement element. They have to first notify the employer carrier that that's what they're requesting and give them reasonable time to do it. And they couldn't have given him reasonable time here because they never requested it before he had the actual treatment. Thank you.
I understand, counsel, since this case involves a cross appeal, you requested to reserve some time for a sure rebuttal. Is that correct?
Yes, Your Honor.
And how much time?
5 minutes, please.
So noted.
May it please the court? My name is Nicolette Sambus. I represent Larry Glenn, the appellee with regards to the initial appeal, and then he's also the appellant with regards to the self-help issue that Your Honor, Ray, just brought up. I'll first address the issues that counsel was addressing with regards to the MMI date. So there are several issues before I go into my argument that I prepared that I want to just respond to with regards to, A, the standard of law, the standard of review for this court. In the initial brief, it references that this may be a de novo standard of review as a question of law, but further on in the argument, I believe the employer carrier concedes the fact that this is a question of fact. The judge of compensation claims is the one who determines maximum medical improvement. It's a question of fact. This is a competent substantial evidence standard of review. There's no issue of law. There's been no argument raised by the employer carrier that it is an issue of law. So this is strictly a competent substantial evidence issue. And with regards to that, it turns on to the facts of MMI, the judge's decision to weigh the evidence, the credibility of the claimant, and the credibility of the doctors that testified. So counsel raised several references Dr. Maniscalco's opinion and tries to rely on that in argument that the judge should have accepted their IME versus the other doctors that testified, including the presumed correct opinion of Dr. Inga, who's the EMA. So simply arguing that their doctor should have been accepted versus the other doctors is not an issue for this court to determine, because that's a factual determination. The judge made the determination, weighed the evidence, provided competent substantial evidence in his final order and in his order denying the motion for rehearing.
Counsel, did Dr. Inga, the EMA, assign an MMI date?
Your Honor, I do not believe that Dr. Inga assigned an MMI date. And as you'll see in the testimony, when he initially provided his report as the presumed correct opinion, he said the claimant was not at MMI, was completely out of work, temporary total disability. He also indicated that the claimant needed a lumbar spine MRI to determine if that level at L3-4 was going to get smaller over time. The claimant subsequently had that updated lumbar MRI in October of 2019. Mind you, that occurred after the doctors at the employer carrier relied upon saying that it's MMI, and said when he was redeposed regarding that updated lumbar MRI, he says he could potentially be at MMI, but if he's showing signs of improvement, he does not, and then he says that he does not believe that he's quite there at MMI and he requires pain management treatment. So I do not believe that the testimony from Dr. Inga, as the judge, and in relying on the factual determinations of the judge of compensation claims, determined that he is not at MMI. So from Dr. Inga's perspective, he says the claimant needs pain management treatment. It's not just an evaluation. And that goes into the other issue of this case, where the employer carrier even today was saying that the authorized treating providers, Dr. Kulkarni and Dr. Patterson, these doctors were not treating providers. They were evals only. And that's extremely important, and that goes also to the cross-appeal issues in this case, where it's the employer carrier trying to dictate and trying to almost put a ruse on the whole matter of accepting compensability of a case because the EMA says that it's a compensable injury and the claimant requires treatment. But when they send the claimant initially to Dr. Patterson, it's for an evaluation. They don't authorize any treatment. The testimony from the judge of the testimony from the claimant is that he didn't get any treatment. The medical records are clear that there's no actual treatment. These doctors just evaluated the claimant and said, no, there's no injury. We're not providing treatment. It's MMI, zero full duty. And that's part of the reason why the judge denied or rejected these doctors' opinions. Patterson did not give the claimant any care. The claimant was forced to ask for a one-time change because Patterson was not giving him any treatment whatsoever. Then the claimant asked for a one-time change in doctors, and they send the claimant to Dr. Kulkarni, who again does not provide any treatment. He just says, MMI, zero full duty, you don't need anything. And in fact, even on direct, when counsel was talking today, she notes that Dr. Kulkarni knew that there was an acceptable condition. Well, that's not clear in the record. That, in fact, that's just the opposite. Dr. Kulkarni, on page 40 of his deposition, confirms, and even in his report, it says eval only. And the question was asked, were you given any sort of indication as to what was accepted as compensable? The doctor says no. He evaluates the claimant. He's a hired gun by the employer carrier and does not provide any treatment for the claimant. And that's what goes to the issue of self-help, where the claimant is forced to utilize the self-help provision of 440.13.2c. So before I go to that part, though, I'd also like to make a note with regards to the judge's rejection of those opinions. So he provided competent substantial evidence as to why he was rejecting Patterson and Kulkarni's opinions regarding MMI. The case law is clear that a judge is allowed to reject even uncontroverted evidence from a medical expert if he provides an explanation as to why he's doing so. Well, here, it's not like it's uncontroverted. There's testimony from Dr. Inga and Dr. Kobe as to why the claimant needs pain management treatment and why it's causally related to the compensable work-related accident. So these doctors say the claimant is not at overall MMI. The claimant needs treatment from a pain management standpoint. No pain management provider actually treated the claimant to where that opinion could be accepted as a MMI date. So the claimant never got the treatment. MMI is clear as being defined as being the point of which no longer lasting recovery can be provided or will be obtained. And even if that treatment is ultimately proved to be unsuccessful, that doesn't negate the fact that the claimant is not at overall MMI. And with regards to work restrictions, there's no dispute that the claimant has work restrictions. Dr. Inga testified that the claimant was completely out of work. And then According to Dr. Kobe, he adopted the restrictions from the functional capacity evaluation. So at that point in time, the judge said that it went from temporary total disability to temporary partial disability, and that's why the award of temporary indemnity benefits was appropriate. So counsel for the employer carrier cited to the Mercado case. In that case, the JCC rejected MMI from 2 doctors because the claimant was still having leg pain and had been looked at, but this court reversed, saying that the expert testimony was unrefuted, which is not the case here, and the judge didn't provide any explanation as to why he was rejecting those opinions. Well, here, the judge clearly did that. The judge did it in his final compensation order, and he did it in his order denying the motion for rehearing. This is just a competent substantial evidence issue where there's an appropriate basis to warrant the claimant not being at MMI. Now, going into the cross-appeal issues, like I talked about earlier, this is a situation where I don't use this term lightly, where there's gamesmanship tactics trying to be utilized to claim that they're adopting the EMA's opinion of a compensable work-related injury, but not actually following through. They're not actually providing the appropriate medical records to the doctors. The claimant in this case filed several motions to strike defenses with regards to the misconduct raised, being provided to the doctors by the employer carrier. Specifically, there was Dr. McGregor's opinion in this case, that you'll see it in the record, where this is the physician that initially treated the claimant, but they only provided pages 1 and 3 of the record to the doctors, including their own IME, Dr. Kulkarni, and even the EMA, where page 2 was extremely important because it references the initial radiculopathy of the claimant and the complaints of pain that the employer carrier tried to dispute and tried to write off as being something that came later on as opposed to being related to the industrial accidents. So that was the initial issue, and then subsequently not providing the actual opinions of Dr. Inga, the presumed correct opinions, accepting a compensable body part, to the alleged treating doctors, Dr. Kulkarni. Also setting these doctors up as evals only, but then subsequently trying to claim them as treating providers. So you have this issue where the doctors aren't being provided the appropriate information that there's a compensable body part, and then the claimant having a compensable body part, a compensable body injury, continuing suffering in his low back, and going to these doctors in an effort to try to get care, and he doesn't get care. So he goes to Dr. Patterson, he doesn't get any care. Then he goes to he asks for a one-time change, and he doesn't get any care from Dr. Kulkarni. So at that point in time, the claimant is forced to utilize the self-help provision and go see Dr. Melvin. Now, Your Honor, you asked when the claimant first saw Dr. Melvin, and that's correct. It was November 14th, 2019. The claimant specifically requests treatment with Dr. Melvin on September 29th, 2020. That is in the record. At page, you'll see Dr.
But that's after he got the treatment, correct?
He sees Dr. Melvin initially on November 14, 2019, but he subsequently continues to see Dr. Melvin. It is not just one evaluation. So he goes to Dr. Melvin because he needs care. He's not getting anything from Kulkarni or Patterson, and he goes to.
Well, let me approach it this way. So the JCC determined that the claimant did not make a specific request for the self-help treatment before he received it. So what evidence in the record contradicts the JCC's finding?
And that's, so I would argue, Your Honor, that the self-help provision, the elements necessary, which is the specific request, is present in not only the petition for benefits and the attachment to the petition for benefits, because you'll see the petition for benefits dated November 18th, 2020, attaches the specific request from the claimant, which was an email to the employer carrier asking for authorization of pain management to include the injections. So there's a specific request in the record dated September 2020 for that care. Okay, the claimant continues to see Dr. Melvin after that initial November 2019 visit. So he goes in November 2019 just for an initial evaluation, but the subsequent request for care and the utilization of the self-help came later in September 2020, September 22nd, 2020, October 20th, 2020. In fact, he continued to treat with Dr. Melvin because he wasn't getting anything from the employer carrier up until May 2021. So it's not just like he sees Dr. Melvin and that initial request didn't happen right away. It's that later on. It's clear in the record that there was a specific request, and you'll see the various the docket is over 400 pleadings long for each date of accident. And you'll see the claimant's filing of the initial request for treatment with Dr. Melvin. He's asking for pain management. He's not getting it. He has to ask for a one-time change. And I believe there's the Lindsay case from 1990, which says that the claimant is not required to make frivolous requests for services where circumstances are such that it is clear that the request will be denied. This is a case where the employer carrier continues to indicate that there's major contributing cause and the claimant doesn't need any care. That's their argument. They raised that in the pretrial, where this is a compensable body part. The presumed correct opinion from the EMA is that the claimant has a compensable injury and requires treatment from a pain management standpoint, and that treatment was not provided. So that's the first element of the self-help provision, which is a specific request for treatment. The second is that the employer is given a reasonable time to provide that treatment. The employer wasn't doing that. They send him for an eval, and they continue to send him to these hired guns, just two, because then they don't do anything else, because they rely on these opinions saying MMI 0, and that, in fact, there's no compensable injury. And that's why the judge rejected those pain management opinions in the first place, because they weren't proper. They weren't consistent with the EMA's opinion. And so that's the competent substantial evidence that goes to the rejection of those pain management alleged treating providers, but they're not treating providers. They're just evals only. That's the second element. The third element is that the treatment is reasonable and medically necessary. The judge of compensation claims does not indicate that there was any finding that the care provided by Dr. Melvin was reasonable and medically necessary. However, it is the claimant's position that the testimony from Dr. Inga and Dr. Kobe indicating that the claimant requires treatment from a pain management standpoint to include the providing of the lumbar epidural steroid injections or blocks, along with anti-inflammatory medications and potentially muscle relaxants. That is the testimony that indicates that the care provided by Dr. Melvin, which the deposition testimony and his medical records are admitted into evidence for factual purposes only, supports that. Yes, Dr. Inga and Dr. Kobe didn't say specifically the words Melvin's care was reasonable and medically necessary, but that goes to that magic word issue. This court has held numerous times, including in the Closet Maid or Sykes decision, that we don't need magic words, right? So it's not the requirement of these doctors to say those magic words. It's clear in the record that the claimant needed pain management treatment. He was not getting the pain management treatment. The treatment from a pain management standpoint is reasonable and medically necessary, and that is why the self-help provision should have been afforded to the claimant, and he should have been awarded reimbursement of the expenses that he incurred while treating with Dr. Melvin. I see that I'm into my rebuttal period, so unless you have any questions, I'll reserve the rest of my time. Thank you.
Thank you, counsel.
May it please the court. I'd like to address the start of counsel's argument where she indicated that we did not bring up the review of as a matter of law. We did. It's in our brief. And we discussed that, and the cases that I cited here today, the arguments that I made today are consistent with our brief. Now, I want to start with the question, Judge Ray, that you had to counsel. You asked her whether Dr. Inga placed the claimant at MMI. He absolutely did. In his first depo, and it's record page 399, he said he'll be at MMI once he gets an updated MRI that shows that the L3-4 finding is resolved or smaller. In his second deposition, record page 704 and 709, he did say, yes, he's at MMI as of October 4th, 2019. That was in response to my question to him. And it's interesting that counsel says that the employer carrier didn't give the claimant any treatment. Unfortunately, that's not what the issue was here, so you have to go back in time onto what the other, the prior litigation was. As a result of Dr. Inga from 3 years ago, he addressed numerous questions, and as a result, and there was like 7-something petitions at the time, and the parties resolved those issues. And in doing so, we agreed to payment of indemnity benefits, and the parties agreed to the language that Dr. Inga testified to. His language in the deposition was he would defer to a pain management doctor to determine whether or not injections are medically necessary and causally related. And that's at page 400 in his first depo, and page 710 because he says it again. And that language is mirrored in the joint stipulation, which is entered, which is in the record at 116, and the parties entered into that on April 29th. And that is in there. The referral was for an evaluation. How can the parties say, no, you're definitely treating him? We are not doctors. The judge is not a doctor. You can't substitute that. So we're saying, based upon what Dr. Inga said, he said he would defer to a pain management doctor to make that determination. That's what we did. And counsel's saying, conflating these issues with we didn't provide him with treatment. We provided him with the evaluation that the parties agreed to. And as I stated, I may have not stated, I know I said it with Dr. Kulkarni, but Dr. Patterson, in his report, he didn't testify. He said he doesn't belong in pain management, but, he could use some oral medications. At that point, the claimant could have requested a follow-up or, hey, can you set me up with a doctor that will give me that? They didn't do that. They went ahead and exercised their one-time change to another physiatrist. That physiatrist also said he agreed with Dr. Patterson. He said, I don't know him, but I know of him. I know he's in the same practice, but I don't find that he needs any of these things either. Okay, so now in regard to the self-help, counsel's arguing that in the midst of the self-help that he should be awarded the self-help that he expended before he ever told the employer carrier. And I don't know of any rule or case law that supports that. The Perotti case is the one that says that you've got to first tell the employer carrier what you're asking for, give them a reasonable time to do it. And then, it has to be medically necessary and causally related. And I think it's the Hidden Day case that establishes that opinion has to come from, I'm sorry, I'm going over,
You may finish up, counsel.
An IME or EMA. Thank you very much. Have a good day.
Thank you, counsel.
With regards to the joint stipulation that counsel just referenced, the joint stipulation says evaluation to determine whether the injections are necessary. That's not the issue. The issue is pain management treatment was recommended by the EMA. That was not provided. It's not an issue because the claimant had to, that's not a petition for benefits that was before this court. That's not for this court to determine. The issue for this court on appellate review is first, whether there's competent, substantial evidence to support the judge of compensation claims decision to determine that the claimant was not at overall MMI and warranted temporary total and temporary partial disability benefits. That's the issue. It's not a question of law. It's a determination of fact. Case law is clear based on Lamar, several other decisions, Crowell, Basefield, all those cases say a finding of fact by the judge of compensation claims cannot be set aside. It's not a review of this court based on the facts. That's the judge's role, and the judge provided the reasoning, rationale based on the logic and reasoning and just general common sense that there's a presumed correct opinion of a compensable injury. Accepting doctors' opinions that go against that would be inconsistent, and that's why he awarded temporary indemnity benefits to the claimant. With regards to the self-help provision, what I didn't address initially is the difference between authorizing and providing. Now, this court explained that difference in Perotti, and then most recently in the Flores decision with regards to one-time change, explained that even further, holding the employer carrier accountable for their ethical duty and responsibility under 440.015 to ensure the quick and efficient delivery of medical benefits to an injured worker, that they have to actually provide care. This court is making it, I believe, a prerogative to show that there's accountability that needs to be on the employer carrier. They need to be responsible for not only just saying that it's authorized, not just sending the claimant for an evaluation, which is not going to do anything, he's not going to get any treatment, to actually providing that care. That was not done here. He didn't get the provision of medical care that he needed, which forced him to utilize the self-help provision. Yes, he went to Dr. Melvin in 2019, but it's that subsequent care after the request was made to the employer carrier, hey, I need more care, you're sending me to these doctors that are just evaluating me and not actually providing the care for a compensable body part, that's at issue with the self-help provision. So here, how can opinions of Dr. Maniscalco be accepted with regards to MMI and work restriction when the physician didn't even say there was a compensable body part or injury? It simply cannot. And with regards to Patterson and Kulkarni, their opinions are the same as the hired gun, Dr. Maniscalco, the EMA for the employer carrier. So it can't be accepted as compensable. It doesn't go with logic. It doesn't go with the law of the case. It doesn't go with the employer carrier's claims that they're a compensable body part. So it's inconsistent, and it should be, and that decision from the judge of compensation claims should be affirmed. And with regards to the self-help provision, because the record is clear that there was a specific request for care, the employer was given a reasonable time to provide that treatment, and he didn't, and they did not. And because that care was determined to be reasonable and medically necessary by Dr. Inga and Dr. Kobe, the claimant respectfully requests this court to reverse and remand for a decision with regards to the self-help provision and the reimbursement of the care with Dr. Melvin. Thank you.
And thank you, counsel, for your respective oral arguments. We will now take a 15-minute recess. We ask counsel to join us on the third floor of Rotunda for coffee. Thank you.
All rise.
Did you see how they cranked up the AC now? Yeah, I know. It's chilly in here.
Finally, halfway through, they did. Yeah, June here, showers. It was the oldest one too. Yeah, that hasn't been updated. The board is beautiful now, but this was just. Yeah, it's not hard. Once there's the board, straightforward. Yeah. It would be nice to have that. Actually, we did have like a room that had like one public school that came in only when the judges used it, but each time, yeah. Hey, you doing good so far? Yeah. It's been a jerk a lot. So
could use block letters. Did you bring a crayon? You're the one speaking, boss. I'm gonna try to move a little closer so that we can. All right. Okay. Brush pad. Do me a favor. Can you reach one of those cups? There's the one. What's that mean? Exactly. Sorry. What's your first page, Soraya? Oh, no, I do. This copy of copy. No, you have to go down there. Soda. West Palm thing is probably on Zoom. What is that? 22nd. Yeah, that's all I could find is a retractable pen today. Yeah, I get it. Yeah, you can do. In fact, this is a law firm's website.
All rise.
Please be seated. Our second case scheduled for oral argument this morning is Patrick Lovick versus Florida Commission on Ethics. You may approach counsel. Counsel, we have allocated 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 3 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Thank you, Your Honor. Dylan Rivers from the Osley and McMullen firm. Here with me is co-counsel Jim McCauley and our client, Mr. Patrick Lobig, in the first row of the gallery. May it please the Court. The question before you is a narrow one. By what agency was my client, Mr. Lobig, employed for purposes of the 2-year post-employment restriction in subsection 112.313 paren 9A4 of Florida statutes? Now, that statute applies generally to agency employees, but the term employed is not defined in the statute. There are, however, more specific statutes governing the very position that my client held before leaving public office, the taxpayer rights advocate. And those statutes expressly state that as of July 1st, 2018, the taxpayer rights advocate is appointed by the Chief Inspector General, must report to the Chief Inspector General, and can only be removed by the Chief Inspector General. These changes were made to the statute in 2018 and were made by the legislature to give that position, to give the taxpayer rights advocate independence from the Department of Revenue. And it makes sense because the taxpayer rights advocate can and truly to be effective should take positions that are adverse to the Department of Revenue. So its actions shouldn't be controlled by the department. And there's a significant body of case law, including from this court, that indicates that control is the essential element in determining an employment relationship. There's payment of wages, which this court has said is the least important. There's also the selection and the power of dismissal to be factored in. And all of those things weigh in favor of the Chief Inspector General, and only the payment of wages relates to the Department of Revenue.
Counsel, I wanted to ask you about the purpose of the statute, and I agree, and certainly the Florida Supreme Court has told us, and certainly in recent cases, that we follow supremacy of the text. If the text is clear and unambiguous, our task is at end. But context also matters, and what, if anything, should we take from the fact that this statute is within the Code of Ethics? And the Code of Ethics has codified a legislative intent, and that includes serving the public interest and doing things that are not adverse to that, kind of as of a paramount concern. So from that context, what should we take of whether that informs the meaning of the word employed?
Well, Your Honor, without taking issue as to the intent behind the ethics statute, I would respond in a couple of ways. Number one, I believe this is a pretty unique situation in that beyond the general ethics statute, we have more specific statutes that specifically define and delineate the contours of this position. And in my research, I was unaware of any cases that in this particular post-employment restriction context where the position in question was specifically delineated by a set of statutes that says this is to whom they report, this is by whom they're employed. Now, admittedly, the word employed is not defined, and the word employed is not defined in either of the statutes that we're talking about here today. But I'd submit to you that the more specific statutes, as a general proposition, the Court is aware should control over more general statutes, and the more specific statutes relate to this position of taxpayer rights advocate. Number two, the record doesn't have a great amount of detail on this, but it does reflect that this position has a minimal number of direct reports, And in the context of the purpose of the ethics statute and in preventing some sort of influence peddling, I don't believe those evils really exist here. I mean, to the extent that this individual would then turn around and advocate to the department, this individual was advocating against the department now, by the very nature of the position, was advocating against the department to an extent now, by the very nature of what the position does. It advocates for taxpayers. I can't imagine a scenario where you're advocating for taxpayers in favor of a position that's been taken by the Department of Revenue. So I, without questioning the intent behind the ethics statutes, I would submit, number one, we have more specific statutes for which the text does tell us by whom this position was employed, and that should control. And number two, I don't believe those evils really would manifest themselves in this particular situation.
Well, let me ask it's an unrelated question, but I do think that it's somewhat relevant. For the secretary of an agency that is appointed by the governor and, certainly has the position at the discretion of the governor, would that person fall under, let's see, the previous, the 3B, or excuse me, I'm sorry, it would be 3A provision of the statute? That says that their agency, for purposes of the ban, is the agency that they work, not their whoever hires and fires them.
If I'm understanding your question correctly, you're asking about would a secretary or an agency head be deemed to be employed by the agency or by the governor who appointed them?
Correct.
Admittedly, that is an analogous question in the sense of the power of appointment and removal, although I would submit that it would be literally impossible to extract the secretary of an agency from any notion of not having influence, of not being able to take advantage of the influence that they were able to exert while they were at that agency. So in your example, I think perhaps the purpose of the statute would clearly come into play in terms of the analysis of employment. Judge, I'm not able to cite them to you off the top of my head. I do know that there were some ethics decisions that did relate to folks in a department heads or secretarial position. I don't recall the specific nature of where they came down on the analysis. Quite frankly, I think it was just assumed that they were employed by that particular agency that they were the head of. So this, to that extent, may be a novel question. Further to the point of the statutory changes, though, that we think weigh strongly in favor of this position being employed by the Chief Inspector General, one of the key aspects of the 2018 amendments to the statutes was to provide the taxpayer rights advocate with the ability to access confidential taxpayer records that have been made confidential by law for many, many years. And that amendment would absolutely not have been necessary if the taxpayer rights advocate remained an employee of the Department of Revenue. You don't need to make that change in the law if that position remained within the Department of Revenue, because it would have had access to confidential taxpayer records.
I know this was addressed in the briefs, but if you can elaborate on the, I guess this is the Commission's argument that the part of the statute that didn't change, or one part that didn't change, is the first sentence that says the position of taxpayers' rights advocate is created within the Department of Revenue, period, and there's no, kind of caveats to that.
Sure, Your Honor, and admittedly, that language sits there in the statute. It existed before, and it continues to exist after the 2018 amendments. And I suppose then we could have an entirely separate brief on what is meant by within the Department of Revenue. Admittedly, the taxpayer rights advocate physically went to work within the Department of Revenue, and for certain, I believe the law says, administrative purposes, there was oversight by the Department of Revenue, but our record reflects on page 28 that the nature of that administrative oversight was in the nature of leave, taking time off, the occupation of physical office space, staffing issues. not substantive in nature, which we would submit was again made to report to and be controlled by the Chief Inspector General within the Governor's office. And here again, if the purpose and intent of laws is to be significant, and I'm not suggesting it's not, then we also have to look at the purpose and intent of those 2018 amendments. And the legislature was clearly making a calculated choice to take the taxpayer rights advocate an arm's length away from the Department of Revenue, to give it a level of independence that it had not previously had before, and to remove it from the control and direction of the Department of Revenue. And by the very nature of the position, that makes sense, because again, the advocate advocates for taxpayers in a manner of speaking against the Department of Revenue. So to address your question, Judge, yes, that language still exists. I don't believe it outweighs what I would consider the clear intent of the 2018 amendments and the actual clear text and black letter of the law of the 2018 amendments. The last thing I would add on that note is the post-employment restriction is penal in nature, and the law tells us that because of that, it must be strictly construed with all doubts being resolved in favor of Mr. Lobig, and we would submit that the Commission seemingly did the opposite, interpreting the post-employment restriction broadly and resolving doubts to a large extent against Mr. Lobig, and a perfect example of that is where the Commission, notwithstanding its determination that Mr. Lobig was employed by the Department of Revenue, gave an admonition, if you will, that he should also not represent clients before the Governor's office. And I think that tells us that there was some question, there was some doubt, and that doubt should have been resolved in favor of construing the post-employment restriction in favor of Mr. Lobig, not against him, but instead the Commission interpreted it against him and then further gave an admonition that he should also not advocate to the Governor's office. But that admonition, I would submit to you, is contrary to the Commission's own precedent, holding that the post-employment restrictions are limited to the agency where someone was actually employed, and the agency, quote unquote, is to be narrowly interpreted. And in that vein, the Commission has specifically held that the fact that an individual works with personnel of an agency, interacts with them, and gets involved in the subject matter of a particular agency does not necessarily trigger the post-employment restriction. We all know that folks within
And
state...
in fact, maybe the reason why the legislature chose to house the position within the agency is if the position's housed within the Inspector General's office, I don't know how many employees they have within the Governor's office, you're going to have less access to the agency itself, right?
I would agree with that, Judge, and returning to the point of access to taxpayer records, while I know we live in an electronic world these days, there also would be some very practical and logistical reasons why this job is significantly more effective and certainly more logistically easy to accomplish its day-to-day operational aspects if it is.
I mean, it's basically sort of a watchdog position, right?
I wouldn't presume to speak for my client or the individual
Well,
who now operates,
no,
but yes.
I'm asking you to speak for the legislature.
I would assume that to be the case, Judge. Yes,
So
absolutely.
that's why you would place that position within the agency.
Well, you certainly wouldn't want to put a watchdog where it can't really watch over anything. I would agree with that, Judge. And I see I'm cutting
I have
into my-
one question, though, and perhaps our presiding judge will extend your time. I want to get a clarification on something in the record.
Sure.
So the commission asserts that among the administrative responsibilities that the Department of Revenue covers is salary and budgeting. But who sets the amount of salary and who sets the budget for this position?
I'm not sure I could answer that, and I don't know that our record reflects that. I do know that our record shows that, to the best of my client's knowledge, the salary was under the Department of Revenue's budget in terms of where the dollars are accounted for.
Yeah, so I think that's to me, I think that is a different issue, where the line is, as opposed to who is making the discretionary decision of how much this person's getting paid and how much budget he or she will be afforded to run the operations.
I understand the distinction you're making. I just am not sure I'm in a position to answer it, Judge. I'm sorry.
Thank you.
Thank you, counsel. We will extend your rebuttal time by 3 minutes. We will also extend the argument time for the appellees by an additional 3 minutes. You may approach counsel.
I think it went well.
Good morning. May it please the court, my name is Graydon Schaefer. I'm here on behalf of the appellee in this matter, the Florida Commission on Ethics. Your Honors, as you've heard this morning, this case concerns Section 112.313, subsection 9A4 of the Florida statutes. And as you've heard, that law places a 2-year prohibition on certain state employees who have left their public positions from returning to represent paying clients before the agencies where they were employed. Now, it's not difficult to understand the legislative purpose behind this statute. It was to make sure that former state employees are not using the contacts and the influence that they held in their former public positions for personal profit in the private sector. Your Honors, let me be very clear. This particular evil the statute was designed to prevent is exactly what the appellant, the former taxpayer rights advocate, is asking you allow him to do this morning.
So where are you deriving that legislative intent from?
Sure. Well, first of all, if you look at when this particular law was passed, we're dealing here with Section 112.313, subsection 9A4. Your Honor, it was passed I believe it was written in 1994, went into effect in 1995. It's a spin-off of language in the Sunshine Amendment to the state constitution. That's found in Article 2, Section 8 of the state constitution. Now, the Sunshine Amendment contains a 2-year legislative ban on legislators returning to lobby paying clients before the legislature. And it contains language in the constitutional prohibition stating that in the future, by law, that 2-year prohibition could be extended to other public officers and employees. Now, when the law was written in 1994, the Commission issued an advisory opinion 94-20, which indicated the intent of the new 2-year statutory ban, which is before you today, is just reflective of the 2-year legislative ban in the state constitution, and that the intent for the two are the same. And the Commission actually in that advisory opinion cited language from Governor Askew that he made around the time that constitutional prohibition was implemented.
Well, let me approach it this way. Is there anything in the text of the statute that, or the context of the statute as it's written that provides the legislative intent?
Your Honor, the statute is very clear that it imposes a 2-year, essentially a 2-year lobbying ban on behalf of paying clients before the entity where an individual is employed. And the Commission has interpreted that, which is a fairly clear language in the statute, to mean the statute was designed to prevent using the contacts and influence you held at the agency where you're employed for personal benefit in the private sector. You know, and again, in that advisory opinion, it cites the language from Governor Askew concerning the Sunshine Amendment, in which he states that the particular purpose of it was to prevent high-ranking state employees from using the contacts and influence that they held in their public service careers for personal benefit in the private sector. I think his language was unjust enrichment. Now, Your Honors, the facts in the law here all show that the Department of Revenue claimed the advocate as an employee and paid his salary. It supervised him and provided him with staff. He was tasked solely with reviewing department decisions and reviewing complaints against department personnel. He even had the discretion to suspend or stay department actions. The advocate's whole position was intertwined with and inseparable from the Department of Revenue. But despite that, he's asking you to allow him to leave that agency and then immediately return to lobby his friends and coworkers for personal profit. And as I'll explain, and as I've already discussed, we feel this is exactly what Section 112.313, subsection 94 is designed to prevent. And it also asks you to ignore some language in the statute setting up the position of the taxpayer rights advocate, which clearly show the legislature considers whoever is serving in that position to be a revenue employee. Let's start there. To be clear, the position exists, as I've already mentioned, solely to respond to problems within the Department of Revenue. And as you've heard this morning, the position was created by Section 20.21, and the responsibilities of the position are still laid out in that statute. That's a law setting up the organizational structure of the Department of Revenue. And as Judge Ray has already pointed out, the statute expressly states the position is created, quote, within the department, And it has language in it stating the position is under the general supervision of the department's executive director for administrative purposes.
Well, so, I mean, one could argue then that's the context for the prior statement. It's within the department for administrative purposes. And would that not inform our decision-making on the meaning of employed?
I think your argument here is that it reflects what the appellant is trying to say, that the administrative housing of the position might not necessarily equal employment. Let me respond to that, Your Honors, by making several points. First of all, I just want to emphasize that the position is, its sole responsibility is concerned the department. It's to respond to taxpayer complaints against department employees, to facilitate the resolution of problems in department procedures, and to prepare an annual report identifying problems within the department. Just want to be clear what the position is involved with. This is not a position with some tertiary or occasional interface with revenue. It is tied to the function of that agency. But even moving beyond that, the state and the Department of Revenue consider the taxpayer rights advocate to be a department employee. Not only does the Department of Revenue claim him as an employee on its website, but on the annual list of financial disclosure filers that the department has to submit each year to the Ethics Commission. That's a list that identifies different department employees have to file a Form 6 or Form 1. Year after year, it claims the advocate is one of its employees. That's before and after the legislative changes in 2018.
Well, if that's the case, then respond to their argument or appellant's argument that why would there need to be statutory authorization to access certain department records?
I would have several responses to that, Your Honor. First and foremost, let me just lay out the basis for that. It's found in Section 213.053. You're correct. In 2018, they did add the advocate to the list of individuals who could access confidential information being held by the department, like information about tax returns and tax administration. I would have 2 points to make to that. My first is that I'm not so sure that that necessarily means the position was being transferred elsewhere. As you've heard this morning, and certainly there's no dispute, that the changes in 2018 were just to increase the autonomy of that position, to free the advocate up from being able to take positions that are contrary to the Department of Revenue when the circumstances warranted. Now, prior to 2018, the position was clearly a department employee, and that meant, as any other employee, the department could restrict the advocate's access to certain information. I think it's very plausible to conclude that by making that change in 2018, the legislature is just sending a very clear message that the department should in no way restrict its employee from the records and information it would need to perform its duties. It was basically just a stopgap to make sure that the advocate continued to act as a watchdog, as Judge Thomas said. My second point, Your Honor, is that let's look at the language of the statute itself. Another change that was made to Section 20.21 in 2018 was to require the advocate to begin preparing a public report that it was to submit to different state officers and employees, such as the governor, the House Speaker, President of the Senate, and the Chief Inspector General. Now, using the appellant's own argument against him, why would it have been necessary to put the Chief Inspector General in the statute as someone to whom that report specifically has to be provided if he was automatically an employee of the Chief Inspector General in the governor's office? Would have been unnecessary to add the Chief Inspector General to that list. Now, you could also couple that with the language in the statute that remains the same, that indicates the position is located within the Department of Revenue. It is completely staffed by the Department of Revenue, and I think the record indicates on page 37 that the advocate actually hires revenue staff to work in his office. You also would have to look at the fact that the position is subject to administrative control of revenue. Those are all factors you can use in the statute that weigh in favor of finding that revenue is the employer here.
Do you dispute, though, that the exclusive authority to control this position's substantive decisions lies with the Chief Inspector General? I
don't think that there's any way to dispute that, Your Honor. The law is very clear that the position for its, in terms of performance of work, does report to the Chief Inspector General's office. But I think to say that he has some type of tertiary contact or just intermittent contact with the Department of Revenue ignores the fact that this position is intertwined with the department and daily interacts with department personnel, and its sole reasons for being, as I've laid out, are to address problems within revenue.
Well, and I think that goes, though, that principle goes to whether the direction, supervision, and control, which is something that we can look to define the word employed. I think both parties agree that that's important in defining employment, who has the direction, supervision, and control of the position. And it sounds to me that substantively, that's the Office of the Inspector General.
Well, Your Honor, that presumes that we have to use the common law to interpret the statute.
Well, isn't the dictionary definition contain those provisions as well? I mean, if that's what you want to pull.
The dictionary definition, as we've laid out, which would be the meaning that we would encourage you to ascribe to the term. You know, we look to Black's Law Dictionary for that, and, you know, the law is very clear. You can look to a dictionary to ascertain the plain and ordinary meaning of the statute. Now, Black's defines the term as it looks at who pays the position's wages and who has the right to control the position through an express or implied contract of hire. Now, here we would argue that is just revenue. It's undisputed that he's considered to be a salaried, contracted revenue employee by the state payroll system, and that the department's executive director does exercise administrative control over the position.
So that brings me to a question that I asked the appellant's counsel. It may not be in the record. If it's not, please don't answer it. But payment of a salary, cutting a check is one thing, but determining the amount of the salary, I think that would be more indicative of an employer-employee relationship. Do you know who makes that decision here?
I do not know who makes that. That's not clear from the record,
Okay.
Judge. Although I will say again, what is clear from the record is that his salary does not come from the budget for the governor's office. It does come only from revenue. Let me attack the question that you asked.
Well,
me.
you would, I think, have to concede, right, that let's say a hypothetical situation not involving this particular advocate. You have a taxpayer advocate working within the department, and the secretary of the agency says, you know, I really don't like the taxpayer advocate. He's making my life miserable. So I want to cut his salary by 40%. Do you think that would be permissible under the current law?
Your Honor, your question is, do I think that would be permissible for the
Do you think
secretary?
the secretary has the power to cut his salary?
I believe that that would be the case, yes. Although, again, it's not clear from the record who sets the
I
salary.
mean,
here.
you're making some excellent arguments regarding the context of the statute. I think those are necessary to consider rather than using a mechanical approach to the word employed. But the Inspector General has the sole power to terminate his employment, right?
That is correct, yes, Your Honor.
And has the sole power to appoint the position, correct?
Yes, Your Honor.
And the sole power to direct the position, right?
That is true. Now, I would make 2 points in response to the questions and the arguments you're raising here. Number one, in the context of state employment, it's not uncommon to have a high-ranking state officer or employee be appointed by another officer or a board that exists in a State Department completely separate and apart from their own. That was encountered by the Ethics Commission in a 2000 advisory opinion that dealt with the executive director of the Department of Revenue. Now, by law, the governor and the cabinet appoint the executive director.
Correct.
But the commission found that because he was classified.
We have a photograph downstairs from our prior executive director in the rotunda. Go ahead.
The commission found that because he was classified by the state as a revenue employee, that's who paid his salary, the commission found that his employer then, for the purpose of this 2-year ban, was just revenue. It's not the appointing
Right,
entity.
but under the constitutional amendment, that's not really persuasive anymore, right?
Well, I'm just citing as an example, though, Your Honor, of if you're going to look purely here to the common law factors, and I'd like to address the common law argument in just a moment, but if you purely look into the common law factors, it might raise a great deal of confusion in interpreting this particular 2-year ban, because many state officers and employees are appointed by entities outside the agency where they clearly work. More than that, many state officers and employees have bifurcated duties so that the oversight of their position is split between several state departments. And this just as an example of that, we issued an opinion, I believe, in again in 2000, it's opinion 2000-11 to the former general counsel for the Department of Environmental Protection. Now, his work was overseen by his superiors at DEP, but also by law he was supposed to provide advice and give guidance to the Board of Trustees of the Internal Improvement Trust Fund. which is a completely separate independent agency
Right, but the
from
Board of
DEP.
Trustees never had the power to fire the general counsel.
No, but under the common law, we would be looking at the most predominant factor here is the report of work. Who has oversight over the performance of your work? Clearly, both DEP and the Board of Trustees of the Internal Improvement Trust Fund had oversight over the former general counsel's work.
What would your response be to the argument that the statute has to be narrowly interpreted?
We would agree with that. Certainly, the statute has to be narrowly interpreted. It's a penal law that does impose penalties on the person against whom it's applied, and so the case law is very clear. We have to construe it in light most favorable to the party against whom it's going to be applied. We would encourage the court to consider that's what we did here. If we were purely looking to where the position has influence, we would probably have concluded that his agency would be both the governor's office as well as revenue. But we constrained ourselves to just looking where he was employed. And given the language in the statute I pointed out and the variety of other factors in terms of how the state has viewed the position that I've also discussed.
Do you think under the statute, hypothetically speaking, not looking at the specific facts here, do you think under the statute the statute can be read to apply to ban a person from multiple agencies?
If the common law is used, I believe that it could.
I mean, does it use the singular or the plural?
I believe that it uses just the singular, Your Honor.
So it seems like the statute might be directed towards one entity, right?
That would be a logical interpretation.
Right.
Now, that's going to create a
I
great...
mean, I think it seems that it's ambiguous here. In other words, you have excellent arguments. You've made excellent arguments today. But we know that the Inspector General, the Chief Inspector, has the sole authority to hire, fire, and direct. So would you say it would be fair to consider this employment situation ambiguous?
Your Honors, we would argue strongly that the place of employment is revenue. And let me address your argument, which has been raised by all of you this morning about the common law. You don't apply the common law and its emphasis on the right to control work.
And my comments aren't an argument, they're just an observation.
Let me comment on your observations then. The common law is not applied in a vacuum. Case law is very clear that you first look to the plain and ordinary meaning of the term. You turn to the common law only if the plain and ordinary meaning is unclear, and even then you should not apply the common law if it's in any way in contravention of the legislature's intention behind a particular statute. Were you to apply the common law here, it's going to allow the advocate to immediately return and represent clients for money before the agency where he was the most embedded, where all of his responsibilities concerned, and frankly before the agency that claimed him as an employee. We would argue that that is not the proper way to approach this statute. And also, very briefly, the cases where the common law has been used to define the term employed, as cited in the appellant's briefs, arise in several contexts. The bulk of the cases that he cites arise in the context of unemployment compensation. Well, Chapter 443, which deals with unemployment compensation, has a provision, Section 443.1216, which indicates the term employment for the purpose of that law has to be interpreted using the common law. And so that's why, in the bulk of cases cited by the appellant, the common law is used, because the statute did not give the courts or any agencies interpreting that law a choice. Here, there's no such language in the statute that says that the Ethics Commission has to use the common law when determining the meaning of employed for the purpose of this 2-year ban.
Look, counsel, as has been indicated, the statute places the responsibility to terminate the advocate solely on the Chief Inspector General. Do you equate the power to terminate with the power to evaluate the advocate as well, to the extent annual evaluations are done?
I think that it's clear here that he reports the Chief Inspector General for work-related purposes, and I think because of that, the Chief Inspector General would most likely have the ability to evaluate his work performance, Your Honor. I see that my time is...
How does that relate to control?
I believe that the right to control here is split. It's split for the purposes of the performance of his work. He reports Chief Inspector General, but the administrative control of the position is kept at revenue.
To the extent the advocate travels on straight business, who signs off on the advocate's travel voucher?
I don't know that that's clear from the record. If that is considered more of an administrative expense, I would assume it'd be the Department of Revenue, but that's not clear from the record. Your Honors, I see that my time has run. Just in closing, we would ask that this Court reject the appellant's arguments and affirm the Commission's advisory opinion findings prohibited by Section 112.313, subsection 9A4, from representing paying clients before the Department of Revenue, which we would assert as his employer, for 2 years upon leaving his position. Thank you.
Your Honors, I heard a couple of points that I wanted to address, legislative intent and the issue of control. With regard to legislative intent, without taking issue as to what the purpose and intent of the ethics statute is, we would submit that it doesn't trump the black letter of the law. The legislature made a decision, and we are here talking about express terms.
Well, the meaning is important. I mean,
without question.
Right.
Your Honor. And
my colleague asked a question that I certainly hadn't considered, and it seems fairly significant, and that is every agency head reports to the governor. And anyone familiar with the Capitol knows that the secretaries work for the governor. And the governor can and has on occasion terminated their services. That termination can occur immediately, and it has, in fact, in the past. So couldn't a secretary argue, using your logic, that, oh, I'm not banned from lobbying my agency for 2 years? I know you said that, in response to my colleague, that that's an interesting question that perhaps can't be answered here and now, but I'm asking you to expand on that.
Fair enough. And, Your Honor, I would respond.
I mean, that would defeat the whole purpose of the statute, right? I mean, that would be a borderline absurd interpretation of the 2-year ban, right?
I would tend to agree with that, and I would submit to you that this case, as I said before, is unique, and I think, in fact, the Commission acknowledged that in their brief. The legislature has clearly treated this position uniquely. It created not just the position itself, but gave us some delineation as to essentially who controls the position to continue using.
But doesn't
the
the governor control the positions of the agency heads?
I would agree with that, Judge.
He appoints, he can terminate, he directs, some more than others. He tells the agency head what policies to pursue, essentially. Some governors have more hands-on approach than others, but so if we were to look at who controls an agency head in terms of the 2-year ban, what would be your answer?
Well, Your Honor, clearly the governor would have an amount of discretion that I don't think is necessarily present here by virtue of the fairly specific statutes that govern this position. The governor obviously would have the ultimate say, and frankly, the governor has the say on other elected officials around the state, mayors and so on and so forth. So certainly the buck would stop with the governor, and so I believe that the element of discretion is certainly greater in that example. And we're not asking the court to ignore the intent of the ethics statute.
If we rule in your favor, can an agency head then ask the commission for an binding advisory opinion and cite this decision and argue that they're not covered by the 2-year ban?
Could they? Sure, I'm sure they could. I would, again, return to the fact that this is a unique situation that I don't think would create any sort of sweeping precedent that would be analogous in all sorts of situations. And in fact, the court could qualify it as such. I mean, that this is a unique position. The legislature has made some very specific decisions and made some very specific provisions in statute. And again,
but to that point, and I asked about this earlier, and I know this is not the exact issue before us, but I do think it helps us by analogy. But that the state officer secretary position may fall under 3A, and you may not know the answer to that. But if that's the case, then the legislature has specifically said that the secretary, the appointed state official, cannot lobby for the agency for which he or she was an officer or member. If we look at 4, what's relevant here, they use the term employment. Now, I think an argument could cut both ways. Imperia materia, perhaps you're trying to, attack the same evil, or perhaps when, you could argue the legislature used specific language in one statute and different language in another, and that would weigh in your client's favor. So.
Are you soliciting an answer? Or?
No, it's just an observation that the hypothetical that we're struggling with may be addressed in the statute, and that was a question that I don't think we have an answer to at this point.
Fair enough. I see I'm out of time. Thank you.
Thank you, counsel. Our third case scheduled for oral argument this morning is Carlos Ferreira versus Alltech Electric Incorporated et al. Again, we will allocate 20 minutes per side for the oral argument. Counsel, you may approach.
Thank you, Your Honor.
And counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor. 6 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Just take a moment. Might be raised all the way up. Okay, thank you. Will you please the court? Thank you, Your Honors. My name is Mike Weiner. I'm here on behalf of the appellant, Carlos Ferreira, along with my co-counsel, Michael Goldstein. Your Honors, this case is sort of a plain and simple case about the mandatory requirements on the part of employer carriers to notify injured workers of their rights in the workers' compensation system and the consequences of what happens when carriers fail to inform injured workers of their duties. And I begin sort of with the thought and the notion that has been embraced in the case law for many, many years, that this is an employer-carrier monitored system. Employer carriers have certain duties and responsibilities, and these are set forth very clearly in the statutory text. And part of these duties require carriers to inform claimants of what their rights are. So a bit of background here, obviously. Mr. Ferreira was an injured worker, suffered a compensable injury to his low back on March 16th of 21 while he was working as an electrician. The carrier authorizes medical care on his behalf, and he's sent to 2 authorized workers' compensation doctors who impose significant light-duty restrictions upon him, which prevent his past relevant work as an electrician. He remains under active care from those physicians, and his medical condition is so severe that his authorized treating orthopedic has recommended lumbar surgery for him, and he's not at maximum medical improvement. And the import of that is he has met, according to the judge's findings, all the prima facie legal requirements to meet his burden for temporary partial disability benefits. Now, this is where sort of things get interesting in the case and why we're here today. The employer did offer him light-duty work in a series of different letters that it sent to him. Admittedly, even in the record, it shows that the carrier even offered what they claimed was suitable work before they even knew what his restrictions were, which kind of begs the question, how could you offer him suitable employment when you don't know what his restrictions are? But be that as it may, the JCC found that the employer did in fact offer suitable employment to the claimant, which the claimant refused. And we're not here to challenge that factual finding. We accept that factual finding as being one by the judge that's supported by competent substantial evidence. However, the record in this case did show and was abundantly clear and without dispute that the carrier never sent the claimant his informational letter for wage loss or temporary partial disability benefits that they're required to send under Section 440.15, subparagraph 4B. And that is where we allege that the judge of compensation claims committed legal error, because the judge found that basically there's no consequence as a result of the carrier's failure to send this mandatory letter. The statute sets it out in unambiguous and mandatory terms, right? That the carrier within 5 days after it has knowledge that the claimant has been released to return to work, that it shall mail an informational letter to the claimant that's adopted by the department, and that letter has to contain eligibility and responsibility information about TPD. Responsibility is the important part of the statutory mandate here. And then Division Rule 69L 3-01915 carries out this legislative mandate, and the Division Rule contains actually a little bit more detail as to what carriers are required to do. And it sets 3 specific mandatory obligations as part of the legislative mandate that are mandated in the rule. Number 1, the carrier shall mail the informational letter to the employee. It has to do it within 5 days. Number 2, the letter shall explain the employee's eligibility for temporary partial disability benefits and the obligation to report earnings. And number 3, the letter must contain certain information. And here we see again part of what the carrier's mandatory rights are, responsibilities are, as part of this self-executing workers' comp system where the carriers hold all control. And what the letter is required to warn injured workers about is that temporary partial disability benefits may be stopped if you refuse suitable employment offered to you. That letter was never sent to Mr. Ferreira in this case. And so the record is very, very clear that he was never given any knowledge of what his responsibilities were as required by the rule and as required by the statute insofar as accepting light duty work. It's without question that he didn't accept the job. The problem is he was never advised what the consequences are to accept that light duty work.
Counsel, if you could respond to the argument that, the legislature, when it wants to impose a sanction or it wants to create a remedy for something, certainly knows how to craft that in the statute, and there's provisions within the workers' comp law in which it has done just that, but it hasn't done that here. So if you could respond to that.
Yeah, and it's a great question, and I'm glad that you asked that. So no question about the fact that when the legislature wants to impose a penalty that it has. But I would submit to you that the precedent from this court has been clear in other circumstances involving very similar issues, that where the carrier does not adhere to its mandatory statutory obligations to inform claimants about their right, this court has interpreted those mandatory obligations as carrying a penalty or a consequence. And that penalty or consequence has always been one of estoppel. And I'll give you 3 main areas of cases where this has been implemented by this court. The first one involves actually the parallel issue of failure to return DWC-19 forms, which actually also is a requirement that's in the same administrative rule. And just as recently as 2011, in the Ricardo case, what this court said was that where the carrier failed to send that informational letter to an injured worker and failed to send the injured worker the DWC-19 or employee earnings reports to complete, that there was a consequence that attached to that, or a penalty, if you will, that attached to that. And the penalty was that even though there's no specific penalty, to answer your question, that's mandated in the text of the statute, this court inferred that there had to be something, right? And the penalty was that the carrier was stopped from asserting the defense that the claimant did not return the forms.
Here the appellee asserts estoppel would not apply because, as I recall, your client was informed there was suitable work available?
Right. He was informed there's suitable work available.
But your argument is that he was never informed if he didn't take it, he was going to lose his benefits?
Precisely, Your Honor. Precisely. It's not just enough. The legislature has been very specific about this requirement, right? It's not just enough that you tell the claimant that there's suitable work, but you have to tell them what the consequences are. And so I want to go back and finish the answer to your question, Judge Ray, about how this court has interpreted those legislative mandates and the consequences that attach to it. So in Ricardo, what this case basically said was, look, it is a condition precedent or an antecedent request that before the claimant has to return these DWC-19 forms, the carrier has to first send him the letter telling him that's his legal responsibility to do that. And that case was quickly followed by another case of this court in the Purdue case, which this court basically said the same thing, that, that's a condition precedent under the Purdue versus Sebring Marine case, that before the claimant has the responsibility to send in the DWC-19 forms, the carrier first has the responsibility to send him the informational letter and tell him that he has the responsibility to do that. And again, it requires no great leap of intellectual faith to get from that point to where we are in this point, because both of these provisions are contained within the very same administrative rule. Matter of fact, one follows each other. Number 3 is the requirement by the department rule that you have to tell the claimant that you could lose your benefits.
That's the narrow issue before us then.
Correct, Your Honor. Correct.
Pure and simple.
Pure and simple.
You didn't send the letter, and therefore we should hold that the waiver of benefits cannot apply.
Precisely. You didn't do what you were supposed to do, and because you didn't do what you are required to do according to the plain text of the statute and the plain text of the administrative rule, you don't get the benefit of the defense. You don't
think that would subject us to criticism of legislating from the bench?
Well, not at all, and I'll tell you why. And this goes back to Judge Ray's question, because first of all, this is what traditionally has been done and how this court has interpreted these rules. So this is exactly what this court did in the Ricardo decision, and it's exactly what this court did in the Purdue decision, albeit not with regard to suitable employment, which was provision 3 of the rule, but with regard to provision 4 of returning the DWC-19 forms. They follow each other in sequential format. So it would be just an interpretation really of the very same rule. And then it's been done in other areas of workers' compensation where carriers have mandatory obligations. And the next example I wanted to give you was with regard to statute of limitations. Under Section 440.185, carriers have a very clear statutory mandate that you are obligated to send to injured workers a brochure that explains their rights regarding the statute of limitations. There is no legislatively proscribed penalty that says if you don't do that, you're stopped from raising the statute of limitations defense. Nonetheless, going back as far as my research told me, back to 1962 in the Florida Supreme Court case of Howanowitz, and been followed by numerous decisions in this case, Timoney versus Tropical Gardens, a number of other cases. But the way the law has always been interpreted by this court with regard to statute of limitations is if the carrier fails to advise an injured worker of what his rights are with respect to the statute of limitations as required by Section 440.185, then the penalty, if you will, or the consequence of not adhering to that legislative requirement is that the carriers are stopped from raising a statute of limitations defense. And then the third area where this court has done this, and it's, again, traces its origins back to the early 1980s, so we have 40 years of jurisprudence that supports this as well, is with regard to wage loss letters. Now, wage loss is really fundamentally the same thing as temporary partial disability, even though it no longer exists in the statute. Wage loss is just post-MMI, whereas temporary and partial disability benefits are pre-MMI. And under the old wage law statute, there was a requirement that injured workers would have to conduct a good faith job search. But as a predicate to conducting that good faith job search, carriers had the responsibility of sending them an informational letter and saying, hey, this is what you have to do in order to make your claim for wage loss benefits. And so these are the cases that I cited in my notice of supplemental authority, which was filed in this case. It involved the Copeland case and the Dan's Plumbing case, where this court held in several different occasions. And there's many other cases cited therein where the same principles were always followed by this court.
Let me ask
and
you
again,
a question, though, on kind of the purpose of this informational letter. So I think it's undisputed that the claimant's doc physician, gave him light work restrictions, and that the employer offered a position with light work. The claimant refused. I mean, is it reasonable to believe that the claimant would suffer no consequence as a result of not going back to work under light duty? I mean, in other words, what was the informational letter designed to inform him of that's not perhaps kind of a common sense understanding?
Yeah, it's a great question, right? I mean, you're dealing with a guy here who's an electrician, and the record testimony shows he's never had a work comp case before. So the claimant as a layperson doesn't know that, hey, if I don't take this job they're offering me, I'm not going to get any lost wage benefits. That's a huge penalty, and that's exactly what the judge found. Had he had known that, at least he would have known what the consequences of his decision not to accept the light duty work were. That, hey, door number 1 here is light duty work. Door number 2 is workers' comp benefits. If you don't take door number 1, door number 2 is closed. That's the purpose of the rule. That's the purpose of the statute. That's why there is a distinct and strict legislative mandate that you have to send the claimant a letter. You have to tell him what his rights are. That's why the division spells it out so clearly.
You mean if he had been told in the letter that if he didn't take the light duty work that was offered to him, he would have forfeited benefits, it would have helped focus his mind?
Well, I think it's a pretty clear warning shot across your bow, right? If you're an injured worker. Hey, I'm not going to get anything if I choose this course of action. But he never had that option because no one ever told him that. And that's really the critical point of this case. The critical point is that carriers have mandatory responsibilities to advise claimants about what their rights and their responsibilities are. And when you don't do that, there's a penalty that attaches to it. And this court, again, has consistently held in DWC 19 form cases, in statute of limitation cases, and as well as in wage loss cases that we cited here in our notice of supplemental authority, that the penalty that attaches to it is one of estoppel. And that was the precise argument that was raised before the judge of compensation claims, and that was the error that he made by not accepting or properly considering that estoppel as a defense.
So let me ask just a fundamental question. In your mind, and again, I understand the case law that you're drawing as analogous, what are the elements of estoppel and how were they not met here?
Yeah, well, there's also estoppel and also what this court has called in prior cases estoppel by notice. So you have detrimental reliance based on a representation that's made to you by a party. I would submit to you here the representation that's made to you by the carrier is not making a representation to you and not telling you of what your rights are. So this is precisely how it's been interpreted in the statute of limitations cases. It's not that the carrier lies to claimants in statute of limitations cases and said, hey, it's 3 years when it's only supposed to be 2 years. It's that the carriers don't send notification at all. And that's why these principles of estoppel, quote unquote, by notice apply, because the carrier fails to do what it's supposed to do. And so it may not necessarily be making a misrepresentation, but it's failing to make a proper statutorily mandated representation to the claimant about here, this is what your rights are.
Do we have any testimony in the record that the claimant relied to his detriment on the lack of notice?
Candidly, there's not, but I would submit to you that it's...
Would be a required element?
Well, I think it's evident by virtue of what we have in terms of the ultimate result here, right? And it's also evident just in terms of, I would suggest, maybe common sense in the sense that if the claimant knew, again, I go back to this metaphor of door number 1 and door number 2, if you don't take door number 1, you don't get any benefits behind door number 2. I mean, what reasonable person would not at least try door number 1? But the point is, he never knew the consequences of the failure to open up door number 1 and at least try the light duty job because the carrier never honored its statutory obligations of notifying him.
You are into your rebuttal time, Counsel.
I'll save the rest for then. Thank you, Your Honors.
You may proceed, Counsel.
May it please the Court. Samuel Spinner on behalf of the Appalese, Alltech, and Business First Insurance Company. Your Honors, this is a case where the appellant is asking this Court to imply a statutory remedy that the legislature never intended in order to prevail on a technicality and obtain TPD benefits in a case where it's undisputed that he was well aware of his rights and obligations regarding TPD and consciously refused to accept any light-duty position that we could have.
Was there any evidence he was aware of the obligation, of the consequence of not taking the light work duty?
Your Honor, I think that it doesn't matter because in this case he testified that he wouldn't have taken it anyway. And so if
He testified he would not have taken it even had he known the consequences?
Well, he didn't say that, oh, now that I know the consequences, I would actually take this work. He was refusing to take the work at any point after March 18th of 2021 until present. There are circumstances I could envision where the failure to send the letter in conjunction with the claimant's testimony that they were unaware of their rights would preclude us from raising a defense. And that's because the entire backdrop of TPD benefits turns on actual or constructive knowledge of your rights and obligations. I think another point that's perhaps been lost is that he filed a petition for benefits for TPD on March 25th. He wasn't assigned the work restriction until March 30th when he went to MD Now after we accepted compensability. And so he already had counsel. He already filed a petition asking for that which he claims now that he was unaware. And so counsel said that it begs the question, how can we offer him light duty if we weren't aware of the restrictions? But at the same time, how can he claim TPD and claim that he's unaware of his rights and obligations for that which he's claiming while being represented by counsel at the same time?
So he refused light duty work after obtaining counsel?
Yes, Your Honor, because his last day that he came into the office was the day after he filed the petition to collect his last paycheck. And if you recall, Mr. Ferreira testified that she was going to ask him to sign a reservation letter because he had called and told her that he was no longer going to be working at Alltech, and he refused to sign that letter. And I think another point, as you brought up, Judge Ray, is that the sole claim in this case is that this is a form of estoppel. And it's very clear from the brief that they're talking about equitable estoppel based on the cases they cite. But this isn't a case where we made a position, we changed our position to the claimant's detrimental reliance. I could envision, again, a scenario where the carrier says, or the employer says, we do not have a light duty position available. And because of that, the claimant doesn't accept the light duty position. And then we turn around and say, no, you rejected the light duty position. That would be estoppel in the context of a TPD benefits claim. But it's just not what happened in this case. And this court has recognized, Judge Thomas and Lewis both concurred in the Mobile Medical Industries versus Quinn case, that when the elements of estoppel are not present in a comp case, you can't just fit that square peg into a round hole and say, no, we're going to grant estoppel despite the legislature not including a provision or any penalty for that matter when, as you noted, Judge Ray, they certainly know how to do it. They've done it in other sections. Additionally, the fact that the claimant has to accept light duty work is in the statute itself. It's not something that's only in the letter that would be sent to him. And so it's not like the letter is the sole basis of any indication of his rights and responsibilities. He had counsel when he was claiming TPD, and for this court to find that he was unaware of his rights and obligations for TPD would require the court to find that neither the doctors nor his own counsel explained to him that he was eligible for restricted work. And again, the claimant testified over and over, I was aware of the restrictions, they told me they had light duty, but I'm not doing it because of his self-diagnosed pain. And this court has repeatedly held that the claimant's self-diagnosis that they are too injured to work cannot overcome uncontroverted medical testimony to the contrary, which shows that they are available to work, and that's exactly what happened in this case.
But that's really not the issue, right? The issue is, was he aware? In other words, did he receive notice from some other source that if he turned down light-duty work, he would lose benefits?
Well, I think that's in the statute itself. He had an attorney who was representing him. He was claiming TPD. And so usually in these cases, it's someone that's not aware of their eligibility for TPD at all. We have someone who's represented by counsel filing a petition for that which he's now claiming he's unaware of the obligations for. And I think you don't get it both ways. All these cases that have talked about TPD where the claimant didn't know about the restrictions involve the claimant saying, either the doctor didn't communicate the restrictions to me, or I wasn't aware there was a job available, or the employer didn't tell me my rights. None of that happened in this case, and that's why to find that the absence of a letter precludes TPD would be awarding the plaintiff for a harm that never actually occurred in this case, because he was well aware of his obligations for that which he was filing a petition to obtain in this case. He wanted TPD, and he was well aware, being represented by counsel, as to his rights and obligations, and again, never even attempted to do a light-duty job. He said, I'm not coming back. His last day of work was March 18th, and before my client even understood what was going on, we already have a petition for benefits asking for TPD. And so I think it's important to recall that all of this could have been avoided from the start if Mr. Ferreira had been honest and upfront with his employer. It's undisputed that instead of telling the employer that he was injured on March 16th, he intentionally didn't tell them. He misrepresented to his supervisor that he was taking off the next day to address a family issue, which wasn't true. And then when he returned to work, the JCC accepted Mr. Lane's testimony that he did offer him a light-duty position at that time. And while the claimant testified otherwise, there's certainly competent substantial evidence to support that. The JCC explained in his order that he, obviously the JCC is in the best position to review, to rule on credibility, to view the witnesses. This was an in-person hearing. And he said, look, the claimant's testimony about what he knew and when he knew it is self-serving, and I'm finding that the testimony from Mr. Lanes and Ms. Rivera was more credible, and competent substantial evidence clearly supports that.
You mean that he knew there was light duty work available?
And that he consciously chose to reject it because of his self-diagnosis and not
Right.
any medical evidence that he was unable to
But
work.
no finding that he knew that that would have required calling his lawyer, I assume, that he knew by turning down light duty work, he waived benefits.
I think that's logical to assume that that would have been communicated to him by counsel.
Well, but there's no finding on that, right?
No, Your Honor, but that was not the specific argument that was made in this case either. The argument is that if you don't send the letter, you can't raise any defenses to TPD whatsoever, notwithstanding the fact that in a separate subsection of the statute which addresses your refusal to take light duty work, it says that you're precluded from TPD if you take that. And it's important to recall that the claimant's saying that we couldn't raise any defenses to TPD if we don't send the letter, that the claimant can come in and say, I knew about my rights and responsibilities, I knew there was light duty work, I chose to reject it, I self-diagnosed myself with being unable to work, but too bad you didn't send the letter, and therefore I went on a technicality. And by the way, the argument is that we can't raise any defenses to TPD. So does that mean that we can't argue the claimant was at MMI? Does that mean we can't argue that 104 weeks have already been paid?
What do you think are the consequences of not mailing the letter?
I think the natural consequence, Judge Thomas, is that it's harder for the carrier to prove that the claimant had knowledge of the light duty work and their eligibility if we don't send the letter. Because again, the backdrop is actual or constructive knowledge. It's not actual knowledge, and I think that's important. It's actual or constructive knowledge that they were aware of the restrictions and the light duty position being available. And counsel agreed that that's undisputed in this case. And so, again, there could be a circumstance where the letter's not sent, and that in conjunction with the claimant's testimony that they were actually unaware, that might be a circumstance where TPD is we can't deny TPD based on the refusal to accept the work. But that's just not the facts in this case. This is a case where the claimant is saying he knew, he said I know this job's available, he testified, I'm not taking any job, I can't do it. And this court has found routinely that you can't overcome medical testimony that you can work, a 20-pound lifting restriction, which, again, my client was offering him over and over. They called him, they texted him, they said, please tell us what happened. Was this a work injury? If so, we need to go through comp. Here's the positions we have available. We sent him letters every 2 weeks from March 26th until all the way in July. And he never came back. He never attempted the light duty work. All he did was sit back and say, you didn't send the letter, so I win no matter the circumstances, no matter the testimony, no matter my actual knowledge, much less constructive knowledge, that I was aware of the rights and obligations for TPD. And I think under these circumstances, one, it's clearly not under the elements of estoppel, as Your Honor, Judge Ray noted, because there was no change in position, there was no detrimental reliance, and the claimant didn't say at any point in either his deposition or at the hearing that I didn't know that I would be unable to claim TPD if I rejected this light duty job. And so that would also have to be an inference that this court drew, because that's just not what he said. And so,
what if it's not estoppel, what would the equitable remedy be called in a situation where, let's use the failure to provide notice that you have to submit forms, that particular case? So if it's not estoppel, what would that be?
well, there would have to be an actual provision in it would have to be some sort of penalty that the legislature put in there, but they didn't in this case, and that's why we're talking about these common law.
Well, but the Appellant's counsel cites the Republic Waste Services case where I think you said the employer here cannot deny benefits by virtue of not completing and submitting the form because the claimant never knew he was supposed to do that in the first instance.
Correct. And to analogize it to this case, that would be the claimant saying, I did get the forms, but the letter somehow didn't comply otherwise with the statute, so therefore I didn't have to return them. And so it goes back to the fact that he actually knew in this case. The issue in the Republic case was that the administrative rule says that if you don't return the completed forms, then you could be, you might be denied TPD. And the case law just says that the employer has to actually send those forms that they're requesting. And so that's different from this case. It would be like the claimant saying, I got the form and I filled it out separate from getting it from you, and despite that, I get to claim TPD despite not returning it to you, even though I got them from my attorney or from another source. And I think that's why to find that the failure to send a letter under this case would have to ignore the actual testimony in the case. It would have to distinguish cases that focus on actual constructive knowledge of your eligibility for TPD and impose a per se rule where the claimant can thumb their nose at the employer carrier and say, I knew everything, doesn't matter, no letter, I win, and no defenses to TPD whatsoever, which again, the claimant's counsel doesn't distinguish between what defenses those are. If you look in the brief, it just says no defenses to TPD. And there's a lot of other defenses other than the claimant's refusal to accept light duty work. So if we don't send a letter, again, does that mean that we have to pay TPD after MMI? Does it mean we have to pay TPD after 104 weeks have already been paid? Because those are the same type of statutory defenses that the failure to accept light duty work falls under. And so I think because of that, again, we're not saying that there could never be a circumstance where the claimant's failure to send a letter, we win no matter what. There's obviously going to be cases where the failure to send a letter and the claimant's testimony that they were actually unaware will preclude the employer carrier from contesting TPD, but that's just not the facts that we have in this case, and it's not the type of case to impose this per se penalty because, again, we're talking about not informing the claimant of that which she was already aware, having counsel, filing petition for benefits, and claiming TPD before he actually had any work restrictions imposed. And so,
Well, I'm trying to remember from the record, so correct me if I'm wrong, wasn't the initial petition for TPD and TTD?
correct, they both were in there, but still the claimant was saying, I'm eligible for TPD benefits without actually being assigned a work restriction at that time and therefore not actually being eligible at the time. And so he tried to get ahead of his rights to TPD, which in fact shows that he was even more aware than in a case where he didn't file the petition until after he had requested light duty work or some other circumstance, because he's asking for something before he's eligible and at the same time saying that, well, even though I know I'm eligible, you didn't send me the letter, I win, case closed. Don't look at the testimony, don't look at the JCC's findings, don't look at his actual constructive knowledge, just look at sending a letter. And by the way, inferring in a statute when the legislature didn't write it, that that is a total defense to, a total estoppel of all TPD defenses.
Counsel, what sanctions or penalties are available to the JCC for the EC's failure to comply with the applicable statute in question here?
With this particular statute, I don't think it's something that the JCC can impose any penalty for. I think that the natural consequence of not sending the letter is that it's much harder for the employer carrier to prove that the claimant knew of the availability for light duty work and rejected it. And the letter doesn't say what the restrictions are. It just says you're eligible for light duty work. And so it's not as if the letter spells out exactly what the job is or when it's available or what your restrictions are. It's just advising them that they may be eligible for TPD and doesn't, at least in the context of this case, say anything different from what the statute says about not accepting light duty work when it's available, which your honors have recognized is a total defense to all benefits during the period of refusal, not even just TPD. And that's because, as this court has recognized, the legislative intent behind the statute is to furnish the claimant's return to work at a reasonable cost to the employer, not to force the employer carrier to grant TPD benefits to an employee who's saying, I'm not returning to work, and without any medical testimony that he was unavailable to work, which again goes against several cases on both fronts, both against the actual and constructive knowledge cases. It goes against the cases that say that the claimant can't say they're unable to work when a doctor says that they can. And all of that, again, in a case where the claimant was aware of his rights and responsibilities.
Assuming for the sake of argument that the elements of estoppel are present in this case, would estoppel have been available to the JCC as a penalty?
Yes, Your Honor. I think
in this case.
Yeah, and to be fair, I interpreted your question more as a statutory penalty. Estoppel is obviously a common law remedy. So yeah, and again, several cases have recognized equitable estoppel in the context of workers' compensation, most notably when an employer carrier denies that a claimant is an employee in a comp case and then turns around in a civil case and says, no, you actually are an employee, so you can't sue us civilly. That's been recognized. But Your Honor, as well as Judge Thomas, have also recognized that when the elements of equitable estoppel are not actually present, when there's no change in position, when there's no reliance to the claimant's detriment, we can't just call it estoppel and apply it in a workers' compensation case, and that's exactly what Your Honors ruled in the Quinn case, where we rejected equitable estoppel, where the elements simply weren't present, because as Judge Ray said, there was no change in position. The employer was not talking out of both sides of their mouth. All of the evidence in this case shows that they were constantly communicating with Mr. Ferreira, asking him for information, asking him to tell them if he was injured at work, explaining that they had light duty available, saying that they would do anything in their power to accommodate his restrictions once they were imposed, because again, he asked for TPD before he had restrictions, and all while he was leaving us in the dark, only to claim that he didn't know about his responsibilities because of a letter. And I think this court should follow the testimony in this case based on what actually occurred and not look solely at the absence of a letter. In another case that might support a finding that the claimant was not aware of their responsibilities if they testify as much, but in a case where they are actually aware, where they're claiming TPD, they're represented by counsel, and they're saying no matter the circumstances, I'm not accepting any light duty job, then the absence of a letter is simply not dispositive under those circumstances. So we respectfully request that this court affirm the JCC's well-reasoned order, reject the estoppel argument as inapplicable under these facts, and hold that the failure to send the letter did not preclude the employer from raising the unjustified refusal to accept light duty work defense. Thank you, Your Honors.
Thank you, counsel.
Thank you, Your Honors. May it please the court. I feel compelled that I have to address one thing about what the record shows. The assertion I think you've heard from appellees is that somehow or another the record showed that the claimant was aware of what the consequences were, was aware.
No, I mean, you're right, there's that impression from his argument, but I've asked him twice.
Okay.
And it's obvious that, I mean, appellee presented an excellent argument, but it's obvious that there's no testimony that he was aware if I turn down light duty work, I'm waiving my right to
Sure,
benefits.
and I just want to expand upon that, and I appreciate that, Your Honor. But there's also, I think, an argument that there was an inference that because he was represented by counsel that meant that he's aware, and that's not the case either. You know, it simply doesn't exist. Now, I would say that the carrier had the right, just like they could ask a claimant, the one sort of loophole that allows you to invade the attorney-client privilege in workers' compensation is as a workers' compensation employer-carrier attorney. You can ask the claimant about, did your lawyer tell you about the statute of limitations? And what this court specifically held years ago was that attorney-client privilege doesn't apply to sort of a recitation of statutory advice. And I would submit the same thing would have been true here.
I think what he's arguing is that your argument is, no disrespect intended, but it's essentially an argument that even though there was no harm here, because he was offered light duty work, he repeatedly refused to go to work. Obviously, one policy in the workers' compensation statute is we do want people to return to work if it's medically appropriate. And he sort of sat on that right and said, I'm going to win because I've got a gotcha here. You didn't send the letter. Therefore, there's no way this can constitute equitable estoppel. What's your response to that?
Well, there was that would imply that there was record testimony that the claimant knew from the very beginning of what the consequences were, and he said, "Okay, well, I know you haven't sent me that letter yet."
I know, but I think
I'm going to game the system, so to speak, and that's not this record.
That's right, and we talked about it during your initial argument. But I think the problem here is there's a little bit of a gap in that. You both agree on certain things. He was offered light duty work. He repeatedly refused it.
No question.
You don't dispute that. There's no dispute he had a lawyer. Nobody called the lawyer and said, hey, by the way, did you tell him he was going to lose his benefits if he didn't accept the light duty work? So appellee is asking this court, I think, to accept an inference. But what we don't know is whether a workers' compensation claimant who was repeatedly offered light duty work and said, no, I'm not going to take it, I'm self-diagnosing myself, and by the way, you forgot to send this letter, so I win. Is that a holding we should make?
Well, it is, and it's not a blanket denial of TPD. Like, in other words, the argument's been made that, well, the carrier's forever stopped from raising any TPD defense. That's not true. First of all, the award of TPD would only exist until the carrier actually sends the letter. Once the claimant gets the letter and the letter says, hey, you don't go to work, you lose your benefits, and he doesn't show up for work, well, guess what? It's rightful that he should lose his benefits at that point, because at that point he's been notified as required by law.
It seems like both of you are asking this court to accept an inference. I think the appellee's argument is we should infer that common sense dictates that he knew there would be consequences for not going to work. I think your argument is based on an inference that we should infer that had he known, if I don't take this light duty work, I'm going to lose my benefits, he would have accepted the work.
And that's
is that a fair description of both arguments?
I mean, I think if you're going to distill it down to one or two sentences, yeah, but I think there's obviously more nuance in that. But, wrapped around that nuance is the mandatory statutory obligation to send the letter, right? And that's what's important. Again, as the appellees argue, it's not that they would be stripped of every TPD defense. No, it's just the defense of light duty work. That's the only defense they're stripped of, and they're only stripped of it for a finite period of time until they send the letter. Once they've sent the letter, they've honored their obligation to this under the statute, and the claimant no longer can wrap himself in the banner of this protection that, hey, you didn't do what you're supposed to do, because they did it at that point. And I just want to close with one last point under the, whether you talk about it in terms of estoppel or a condition precedent, this court, because we've heard it discussed both ways, Judge Ray, and this court in the most recently in the Ricardo case talked about this as being a condition precedent, right, or antecedent request, that in order for the carrier to avail itself of the defense that you didn't submit the DWC 19 forms, the condition precedent, if you will, or the antecedent request, if you will, is the carrier has to send the letter and has to send the form. So we don't necessarily have to tether ourselves to the term of art of estoppel. We can use what this court has used, the condition precedent term instead. Thank you very much for your time, Your Honors.
Thank you, counsels, for your respectful oral arguments. This concludes our oral arguments this morning. We're in recess.
All rise.